Okay, welcome to our channel once again. Today we are back on the ECHR. I think following on from my previous video, I did share with you a story of a young man who was taken into police custody and subsequently into a UK prison, who died in a few days. There was a lot of cover-up. Relevant information was not applied in court, obviously in the inquest leading on to his death. So much information was missing, lots of lies, and justice was not delivered to the family. And so this brings us to the European Court on Human Rights, the ECHR, which has been a political hot potato in recent times, following on from obviously the works of the UK Reform Party leader and my own local MP, Nigel Farage, on one side with Kemi Badenoch, head of the obviously shadow PM for the Conservative, and on the other hand, on the positive side being the PM, Sir Keir Starmer, and also the retired Judge Tim Icke from the European Court of Human Rights. Now, on these two camps, we know that the Prime Minister, Sir Keir Starmer, is in support of Britain remaining in the ECHR. And also, we've also heard from the King's Counsellor, being Sir Tim Icke, who has just retired from the European Court of Human Rights. And basically, the information he brings out, confirming the relevance of why Britain should continue to remain in the ECHR and also remain in the court, the European Court of Human Rights. I think it's relevant, the information that has been received from King's Counsellor Tim Icke, on the basis that he has worked in the courts for many years, basically 9 years. He served a 9-year term in the court. And I think that being on the job, what he says is probably more relevant and have more weight than any other person. And obviously he mentions the issue of the Hillsborough disaster, the reopening of that case being obviously one of the triumphs of UK remaining in the European courts and the European Convention on Human Rights. And basically the families whose family members suffered as victims of the Hillsborough disaster, with the reopening of the case after so many years, sort of began to see some sort of justice and obviously accountability on the part of those who caused that disaster. But it also goes on to talk about things like obviously the issues with gender issues within the army, which has also been resolved. There is another case that he talks about. What is the name of it? I'm going to check this. It talks about the exposure of the, I think, Thalidomide scandal. I don't know what that scandal is, but you know. So he talks about the relevance of Britain remaining in this convention. Obviously, the Prime Minister knowing the importance, he also being a former, I think, working in the Crown Prosecution Service, he is also very much vested in the law, and therefore he knows these things and how relevant they can be as an additional step. That is, if people do not find justice within the UK courts. But Tim Icke also goes on to talk about the relevance of UK human rights laws and how UK, obviously, courts have successfully process a lot of deportations where immigration was concerned. So he does bring to the fore that immigration in itself has not been a real issue, which is what maybe Nigel Farage and his cronies have been using as as a tool or to basically advocate for Britain to come out of the European Convention on Human Rights. Obviously, we also know that Kemi Badenoch, being the shadow PM, talks about how our coming out of it will help secure UK borders. All these things, in reality, it is hard to believe that these are real facts. I think sometimes the concern should be on maybe governments focusing on building this economy and just putting in rules and regulations to sort of maybe regulate things like prices and just to improve the standard of living of people in the UK rather than us that continuous bashing of these kind of laws, because Tim Icke did confirm that a report that was obviously that was made available in the Oxford research actually did show that out of the 29 cases that came to the European Court of Human Rights on maybe UK deportation orders, 16 of them, the court did find that the UK courts had not breached any laws and these deportations were indeed carried out. However, with the remaining that have not basically passed through that process, yes, it's possible that maybe one or two may not necessarily maybe the UK courts may not necessarily have acted in a way that really stays within the law. And so I guess if these people are members of your own family, you surely want them to have justice. And this is why it is necessary, obviously, for Britain to remain in the ECHR, being the European Convention on Human Rights, and also in the European Court of Human Rights. As I know, this case that I mentioned in my last video, I must also admit that, when I was making that video, I think I was sort of, the articles, I was jumping over some of them, where I was sort of mixing some of them. So the video today, I am just going to go into the ECHR and just at least read about 13 of the articles, just to make people aware what these articles are. And so with a case like that, it was necessary, or it is necessary, for us to remain in this convention as a way to protect people who do not necessarily find that justice within the United Kingdom. And so this is where we are. At this stage, obviously the debate has been on the fact that the PM and this retired judge, Tim Icke, has been advocating for us to remain. And then we have the likes of Nigel Farage and Kemi Badenoch saying that we should get out of it. But obviously in the previous videos I've discussed why, set things are no good to us as a people, and no good to the same people that are actually advocating for this type of a thing, in the sense that I think that the position of the shadow Prime Minister has been made possible here in the UK because of these type of international and domestic human rights laws. And so at this stage, I will move on to the next stage, where I bring to you the ECHR, being the articles of the ECHR. So if you bear with me, we'll get that done. So here we are. This is the articles of the European Convention on Human Rights. And so for a starter, I will just go onto the left side and give a summary of the various articles and then try to go into details in reading some of them. And the relevance of this type of a video is just to allow people who do not have time to read to be able to just come onto YouTube and just, go through or listen through these articles so that they indeed get to know what they are and they get to understand what the Prime Minister is fighting for the people, i.e., to remain in the convention, and also to expose those who do not want the country to remain in the convention. So on the left side here, as we see, on the left side, so we see the Article 2 is the right to life. So this is where it all starts. The Article 2 is the right to life. We're going to go into the details of it. Then Article 3 is the freedom from torture and inhumane or degrading treatment. So obviously, your right to life, there is nothing wrong. These international treaties were established after the post-war era. All the things that happened in the First and the Second World Wars, these were put in place to protect the individual from tyrants, from dictators, from fascists, and also, I'm very sure, the activities of the Nazis at that time, just to protect all citizens from an oppressive state. So the right to life, that is Article 2. And obviously, Article 3 being freedom from torture, inhumane or degrading treatment. Article 4 talks about freedom from slavery and forced labor. Surely, if if yourself or any member of your family is being enslaved and used as forced labor, is something that is not going to make anybody happy. Then Article 5 is the right to liberty and security. Article 6 is the right to a fair trial. So we see from the previous case that I mentioned about this young man that was taken into a UK prison and suddenly died, we see that Article 2 was breached, which was his right to life. Then we see that Article 6 was also breached in his right to a fair trial. It is also possible that Article 3, which is, I'll just go back to that. So Article 3, which is freedom from torture and inhumane or degradable treatment, was also breached, because we see from that case that the young man was not looked after whilst he was in prison. And part of him being put in an isolated cell that was being filled with a hot water tap that was broken, in a way, means that his life, he was basically treated in a cruel and in an inhumane manner. So we see here where the case went to a UK court just for his inquest, and obviously there was a lot of missing documents. CCTV was not provided, expert witness account was not used, but then the verdict was rich, so you could see that there was no fair trial either. So this is where, and this can happen to anybody in the UK. What happened to this family could happen to anybody, and so therefore this is why it is relevant that the country remains in the ECHR, so that if the family was resourced, they will have that opportunity to actually take the matter to a higher court, which is the European Court. So Article 8 talks about the respect for your private and family life. Then Article 9 talks about freedom of thought, belief, and religion. So once again, we see that also in the UK in recent times, a lot of Christian preachers on the streets are being persecuted or arrested or harassed. And so all these are basically protected under Article 9 of the ECHR, where obviously indicating that people have a right to establish their own belief and also to share that belief, whether in public or in private, as long as they are not harming anybody. So Article 10 is the freedom of expression. Article 11, freedom of assembly and association. This is also, we have also seen this in the UK, probably in the time of when Suella Braverman was the Home Secretary. She wanted to basically curb people's right to assembly and association. Obviously, if people were not happy and they wanted to demonstrate on anything, she wanted that right to be taken away from the people. And in the way, he was one of the strong advocates for UK, or maybe initiators for the UK to come out of the ECHR. And so we also see her failed Rwanda scheme, government Rwanda scheme, which eventually became law. But once again, the law was cancelled or discarded by the current PM, being Sir Keir Starmer. The right to marry is Article 12, Article 14, protection from discrimination. And so it goes on. Then there is also the protocols. So the protocols of the ECHR, we will tackle that in the next video. But for now, we will just go through probably the 14 plain articles. But you see that there are protocols. Once these articles are established or international treaties are established, there are certain areas that are not originally covered as such. And so these, as the article grows, obviously, as obviously the member nations come together, realizing that certain matters have not been addressed, they do address them in a form of subsequent protocol. So you can see here there is the first protocol, and I'm sure that there are more protocols of the ECHR which we will cover in subsequent videos. But in the meantime, we will just go back and basically continue from reading through articles through the right to life. So what the laws say, and it says that this text is taken directly from the Human Rights Act. So what we also see is that these international treaties, the UK human rights laws, are actually built upon these international treaties. So whereas we have issues with UK migrations, UK migration issue, KC, King's Counsellor Tim Icke, who is retired from the European Court of Human Rights, have confirmed that indeed the UK courts have been able to handle all migration issues. But where, we have the shadow PM talk about UK border controls, I, in recent times, was in mainland Europe, and the controls were excessive. Going out, you went through 2 levels of controls where people or maybe officers at the borders will look at your passport and look at your face as if the passport did not belong to you. And then when you got to the other side, it was the same. On your way back, it was the same. So this, I think, is adequate controls. Today, we also hear, obviously, economic growth from the Bank of England, where they are somehow, Andy Bailey, being the governor of the Bank of England, is unhappy about Brexit and its effect on the UK economy. That we also see our Chancellor, Angela Reeves, also unhappy about the economy and talking about Brexit, how that has affected us. And so you can see that if we go ahead once again to get out of this ECHR, we will only turn around in a few years later, regretting such actions. But we see, obviously, the likes of Nigel Farage campaigning strongly for his UK Reform Party, using immigration once again as a political football, as if getting the UK out of the EU has not been enough a blow to the economy. He does this again, and obviously, if people that do not know these international treaties and how they protect us will surely run behind him and make another mistake. So Article 2, the right to life, says everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which the penalty is provided by law. Then the clause 2, deprivation of life shall not be regarded as inflicted in contravention of this article when it results from the use of force which is more than absolutely necessary in defense of any person from unlawful violence, in order to effect a lawful arrest, or to prevent the escape of a person lawfully detained, and in action lawfully taken for the purpose of quarrel, a rout, or insurrection. And so this article obviously protects the rights of the individual, of the persons, and in a lawful manner, that even if you are detaining somebody, the force that you use must be reasonable force, that you cannot basically use violent means to obviously detain a person or somehow take away their rights and take away their right to life. And so it talks about Article 1 of Protocol 13 for the wording in the Act that makes death penalty illegal in the UK. And so these are the protocols that we mentioned about, that obviously they do make the death penalty illegal. So most of the member nations that have signed up to this convention, obviously under Article 1 of Protocol 13, have actually accepted not to obviously exercise death penalty in those respective countries. There is a case, obviously, Pretty versus the United Kingdom, 2002. I will not go into this, but if you are interested, you can actually research this case yourself to know the content of what it was. So I will just move on to Article 3. So here we are, Article 3, protection. Article 3 protects you from torture, mental or physical, and inhumane or degrading treatment or punishment. So the case that I did mention in my previous video was a breach of Article 2, Article 3, and Article 6. And so this is how, if the family was resourced and they had the energy to pursue the case at the higher court, then they could have found that justice at the European Court of Human Rights. So Article 3, that talks about your right, your protection from torture, be it physical or mental, and inhumane or degrading treatment or punishment. As you expect, public authorities must not inflict this sort of treatment on you. They must also protect you if someone else is treating you in this way. If they know this right is being breached, they must intervene to stop it. The state must also investigate credible allegations of such treatment, including by third parties. So we see here very clearly, this is a great article. It is good for every citizen of this country, and this is the reason why this nation, United Kingdom, must remain in the ECHR, because here we are. It talks about how people in public authority are not to treat you, the individual, in a way that basically in a way of torture. That if they know of anybody treating you in that way, that they should stop it, stop that, and they shouldn't breach this law. And also they must investigate if there is any allegation of such against a person by a third party. So we see that in the previous case, or in my previous video, the case that I raised, that young man's life was not protected by anybody. And so this is where I say that indeed, if the family had wanted to push further to that level, then surely justice would have come from these articles. So torture occurs when someone deliberately causes serious and cruel pain or suffering, physical or mental, to another person. That this might be to punish someone or to intimidate or obtain information from them. And so you see that it also makes it unlawful even if it's a public authority, even if it's the police obtaining information from you, and they use any kind of force or a cruel way to obtain this information, be it physical or mental, then surely that is also a breach of Article 3. We may also find people, people that are used for human trafficking, the people that are used as forced labor or slave labor. There are many people whose life are being curtailed in such a manner, and by so staying in line with these articles, then really state authorities are obliged to protect the rights of such people and bring those perpetrators to justice. So inhumane and degrading treatment is inhumane treatment or punishment is treatment which causes intense physical or mental suffering. Degrading treatment means treatment that is extremely humiliating and undignified. This concept is based on the principle of dignity, the innate value of all human beings. So there couldn't be anything wrong with this article. It's a great article, and surely it is right for this nation to remain in the ECHR. Inhumane or degrading treatment could include serious physical assault, very severe detention conditions or restraint, serious physical or psychological abuse in a health or a care setting, threatening to torture someone if the threat is real and immediate. Whether ill treatment reaches a level that breaches Article 3 depends on several factors. These include the duration of the treatment, its physical or mental effect, and the sex, age, vulnerability, and health of the victim. So these are all stated here very clearly what they are. We know that in the times of the COVID, in a manner that families were treated, and especially in places like care homes, and people not gaining access to their loved ones even at the point of death. These things could be challenged and under this article, on the basis that was it really relevant, and the duration, could people have been allowed to see their loved ones at the times where they had passed? A lot of questions could be asked, based on this article. Restrictions to the right to freedom from torture and inhumane or degrading treatment. Let's look, maybe this could be further articles. So let's see what it is. Your right not to be tortured or treated in an inhumane or degrading way is absolute. This means it must never be limited or restricted in any way. For example, a public authority can never use lack of resources as a defense against accusation that it has treated someone in an inhumane or degrading way. So this is also very interesting. Many a times we see that if let's say a government office, or some sort of a main or a major institution are supposed to maybe carry out certain works, obviously to protect people's rights, and they don't. Sometimes we hear things like, oh, we didn't have enough staff. They make so many excuses. And if this was in relations to anybody obviously suffering some sort of inhumane and degrading treatment, then such excuses will not be permitted under this law. And so, it goes on. Once again, there is a case here. As I scroll down, it's just Chahal versus the United Kingdom in 1996. So this could also be a case where, if you're interested, you can actually research further on it to know what it indeed was. So we go to Article 4. So here we are, Article 4. Article 4 protects your right not to be held in slavery or servitude or made to do forced or compulsory labor. And so we know for a fact that once again in the UK, some people are brought into the country and kept in a confined place and are basically used as forced labor. And this, once again, we know that by this law that the state or the police are supposed to be protecting such people, or are supposed to be combating, which I think they do. They do, indeed, they do. We do hear cases. We do hear cases where such things are done, where such things are carried out, and so this is being done in the UK. Let's see. Pause for 1 week. Okay. So yes, indeed, these things do happen. And so forced labor, slavery, is when someone owns you like a piece of property. Servitude is similar to slavery. You might provide service to a person for no reward and be unable to stop due to coercion, but the person does not own you. Forced or compulsory labor means you are forced to do work that you have not agreed to do under the threat of punishment. So here it makes it very clearly there is nothing wrong. Who in their right sense of mind want to get out of these laws that protects humanity, wherever they may be? Who wants to get out of these laws? So as we bring this information to you, if you don't have time to read, you can actually just listen to these laws and get to know the importance of why the British Prime Minister, Sir Keir Starmer, and also the retired King's Counsellor, Tim Icke, is actually advocating for UK to remain in the Echr and also the European Court of Human Rights. And for us, we know the errors that were made in the decision of the Brexit that we must guard ourselves from falling into that trap the second time. Restrictions to the right to freedom. Your right to be protected against slavery and servitude is absolute, which means that it can never be restricted. The right relating to forced labor is also absolute. However, it does not apply to work that you have to do as part of a prison community sentence. The government requires you to do in a state of emergency, such as after a natural man-made disaster, and in part of normal civic obligations like jury service. So it makes it clear here where the restrictions are, and these are very reasonable restrictions to that right to freedom. And so, if one has to do a prison community service, then indeed they must do it. And if there's a state of emergency, then the state obviously will require its citizens to do certain works. Then everybody is obliged by the decree of the state to do it. And also if it's a civic obligation like a jury service. So these are all very reasonable laws, and one cannot understand why anybody would like our nation to get out of these laws, international laws. So what do we have here? We have does it go on about the Article 4 prohibition of slavery and forced labor? No one shall be held in slavery or servitude. So this is where it's sort of making it clear. No one shall be required. These are the clauses under Article 4. So clause 2 says no one shall be required to perform forced or compulsory labor. Let's keep going down. 3. For the purpose of this article, the term forced or compulsory labor shall not include any work required to be done in the ordinary course of detention imposed according to the provision of Article 5 of this convention, or during conditional release from such detentions in a service of a military character, or in case of conscientious objections in countries where they are recognized service extracted instead of compulsory military service, in a service extracted in the case of an emergency or calamity threatening the life or well-being of the community, in a work or service which forms part of a normal service. So this goes on once again back to the restrictions on that article. But once again, we see a case by Celiadin versus France 2005. So this is a case that you can once again go ahead to research yourself. So we go on further to Article 5. So Article 5 is protect your right to liberty and security. So that as well, we're going to go through it. I'm not going to spend too much time in digesting this article. I'll just read it as it is. It focuses on protecting individuals' freedom from unreasonable detention, as opposed to protecting personal safety. You have a right to your personal freedom. This means you must not be in prison or detained without good reason. Let's go down here. If you are arrested, the Human Rights Act protects that you have the right to be told properly in a language you understand why you have been arrested and what charges you face. Be taken to court promptly and have a trial within a reasonable time, or to bail, temporary release while the court process continue, which may be subject to condition to guarantee you appear at trial. If you are arrested or detain. The Human Rights Acts provide that you have the right to ask a court to decide quickly if your detention is lawful and order your release, if not, a compensation if you have been unlawfully detained. So this goes on, and once again, there may be restrictions to the right to liberty. We will probably go through those restrictions because the restrictions are very relevant to help you to understand. So restrictions to the right to liberty and security. There are certain circumstances in which public authorities can detain you as long as they act within the law. This applies, for example, if you have been found guilty of a crime and sentenced to prison. You have not done something a court has ordered you to do that you are legally required to do. There is reasonable suspicion that you have committed a crime. Someone is trying to stop you committing a crime, or they are trying to stop you running away from a crime. You have a mental health condition which makes it necessary to detain you. You are capable of spreading infectious disease, or have a mental health impairment that is sufficiently serious to warrant detention. So these are the restrictions, and it goes on. The restrictions are important for you to understand, so that you know that your right to liberty is somehow not absolute in that respect. You have a mental health condition which makes it necessary to detain you. You are capable of spreading infectious diseases. You are under 18 and a court has ordered that you are detained, for example, in a care home, or you are detained before legal proceedings take place. You are attempting to enter the country illegally, or action is being taken against you that might result in you being deported or extradited, sent to a country where you have been accused of a crime. So these are the restrictions to Article 5. Let's carry on. So Article 6, the right to a fair trial. I think obviously I will basically go through Article 6 and end the video here and carry on from Article 6 in our next video. So Article 6, which was also breached under the case that was presented in my previous video. Article 6 talks about, or it protects your right to a fair trial. You have the right to a fair and public trial or hearing if you are charged with a criminal offense and have to go to court, or a public authority is making a decision that has an impact on your civil rights or obligation. In this context, your civil rights and obligation are those recognized in areas of UK law, such as property law, planning law, family law, contract law, employment law. It is a good idea to get further advice if you think the right to a fair and public hearing might apply to your case. So let's go further. Fair and public hearing. So this is defining what fair and public hearing is. You have the right to a fair and public hearing that, 1, is held within a reasonable time, 2, is heard by an independent and impartial decision maker, 3, it gives you all the relevant information, 4, is open to the public, although the press and the public can be excluded for highly sensitive cases, 5, allow you representation and an interpreter where appropriate, and is followed by a public decision. You also have the right to an explanation of how the court or decision-making authority reaches its decision. So we see here in that particular case in my previous video, we see here the independence and the impartiality of the judge, because the judge, as I mentioned in the previous video, that he gave instructions for the person that was heading the jury to come up with a particular verdict. Whether they knew that we were still online or not, that was what was said. On the next day, that was the decision that came from the verdict, so or from the jury. And so therefore that tells you that it was done in an impartial setting. And also it talks about giving relevant information. We also know that there was a lot of missing information. Obviously the logbook was missing, CCTV information was not provided, expert witness statements were not even considered. It was mentioned that a person needed to come with that information, they didn't, and the judge will not wait for that to actually to be used in making that decision. Then I guess, let's see, here is open to public hearing, okay, and allow you representation and interpreter. Okay, so that was in effect not a problem, but how the decision was reached was also questionable. So let's see here, your right at a criminal trial. So here it talks about a criminal trial. Maybe there is also a civil trial. So we see what the details are. You have the right to be presumed innocent until you are proven guilty. To be told as early as possible what you are accused of. Remain silent. Have enough time to prepare your case. Legal aid or a lawyer if you cannot afford one, and this is needed for justice to be served. Attend your trial. Access all relevant information. Put forward your side of the case at trial. Question the main witness against you and call other witnesses, and have an interpreter if you need one. So these are all good things. Sometimes the challenge is the issue of legal aid and finding a lawyer or a good lawyer to represent you when you don't have the funding and you have to depend on legal aid. I don't even know if any legal aid exists here in the UK today. Everybody must have equal access to the court under the Human Rights Act. This includes a right to bring a civil case, a case between individuals or organizations, although this right can be restricted in some situations. So let's look at the restrictions. So restrictions in Article 6 says restrictions to the right to a fair trial. The right to a fair and public hearing does not always apply to cases involving migration law, extradition, tax, and voting rights. There is also no automatic right to an appeal, an application to a higher court for the reversal of the decision of a lower court. The right of access to the court can be restricted, for example, if you keep bringing cases without merit, miss the time limit for bringing a case. There are times when the public and press are denied access to a hearing. This can happen in the interest of protecting morals, public order, or national security, children and young people, or privacy. The court might also decide to exclude the public or press if they think that their presence is not in the interest of justice. And so at this stage, I will bring this issue of the ECHR, this first part, to a close. We will continue our next video from Article 7 of the ECHR. Then we will also continue to look at the respective protocols. Yes. Okay. So once again, thank you for obviously staying on and listening to the contents of this video. As it ended in Article 6 of the ECHR, we will cover the plain articles to Article 14, from 7 to 14 in our next video. And so when you obviously listen to the contents of the articles of the ECHR, you kind of wonder why anybody in their right sense of mind would like the nation to come out of these international human rights treaties, in as much as the King's Counselor, retired Tim Icke from the European Court of Human Rights, have stressed the importance of the UK remaining in the ECHR and also in the court. We know that these articles are not harmful, they are rather good for the life of every citizen in this country. So I hope that, in shedding some light on these articles of the ECHR, it will indeed help people who don't have the time or don't know much about ECHR to gain some knowledge. If you don't have time to read it, just watch this video. You can listen to it as I've read those articles, and you can surely understand why the British PM wants to protect this nation and want this nation, this United Kingdom, to remain in the ECHR. Thank you for watching this video. Everything that has been said here is my own opinion and my own perspective from the information that I have gathered. Surely it's a learning curve. I want to hear from you. If you disagree with the content and you think that Britain should get out of the ECHR, then be polite and also basically put your comments in the comments section. Let us know what your contribution is and why you indeed think that it will be a good idea for the UK to get out of the ECHR. So once again, thank you for watching this video. We will hopefully come back again to continue from Article 7 and subsequently look at the respective protocols. So until our next video, thank you for staying with us. Have a good night.